Okay, good morning everybody. Welcome to this licensing committee for today, January 10th, 2024. We're here to hear an application for a premises licence for the last pub standing. The committee today is myself, Councillor Jacob Ashley, who will be chairing, and the other councillors are Councillor Caroline Ackroyd and Councillor Claire. David, just to my left here, is our legal representative, so we'll be relying on him on this today. Could we perhaps go around and just make sure we know who everybody is here? If you can perhaps start, please.
My name's Hugh Bernard. I'm an audio engineer. I'm here on behalf of Simon from Last Standing.
Good morning. I'm Simon Peters, the applicant for the licensed premises. Last Pub Standing.
Yes, morning Chair. Neil McCann, assistant to the applicant.
Tom Dawson, Environmental Protection Officer for Norwich City Council.
Morning, I'm Maxine Fuller, Licensing Advisor.
Leonie Bowitz, Committee Officer, just here to live stream the meeting.
Great, thank you very much everybody. I'll now hand over to Maxine, who will be presenting the report.
Chair, with your permission, just to make sure everybody's got everything before we start. So everybody should have the agenda. Then supplementary to the agenda, the applicant's written submissions from Keystone Law, and that includes a report, noise report, and also an email 4th January, Thursday 4th of January, between Mr McCann and Mr Dawson.
And various pictures.
And pictures indeed, yeah. And in addition to those, we have the written submission from Environmental Health recently received. In addition to that, I think circulating today is a plan A4 showing locations.
Oh, I've not seen that.
So just to confirm, everybody has had an opportunity to see those documents. There are no additional ones, as I understand.
Okay, yes, if you want to keep hold of a copy of that. So we've all got the relevant papers all right, papers. So thank you, David. Maxine, I'm handing to you to present the report, please.
Members are asked in accordance with the delegation of licensing functions contained in the Norwich City Council Statement of Licensing Policy, Licensing Act 2003, to consider the application for the grant of a premises licence in respect of Last Pub Standing, 27 to 29 King Street, Norwich, NR1 1PD, following the receipt of relevant representation. It is recommended that members determine the application to grant the premises licence in accordance with the Licensing Act 2003 and subsequent regulations, guidance issued under Section 182 of the Licensing Act 2003, and Norwich City Council Statement of Licensing Policy. The applicant is Last Pub Standing Limited, and the proposed DPS is Simon Peters. The application seeks to allow the licensable activities, times and opening hours as set out in the application form, which is attached to Appendix A. This also includes the steps proposed to promote the licensing objectives, which is the operating schedule. This premises was previously licensed, however the premises licence holder went into administration and the premises licence lapsed. 10 applications or temporary event notice applications have been granted to enable some trading there. Representation was received from the police. Copy is attached to Appendix B. We have received confirmation that the client accepts the police conditions, and so the police have withdrawn the objection. We've received representation from the Public Protection Team. A copy of this is attached to Appendix C. And we've also received representation from 2 local residents, and their copies are attached to Appendix D. In determining the application with a view to promoting the licensing objectives, the subcommittee must give appropriate weight to the steps that are appropriate to promote the licensing objectives, that is to say, the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. The representations, including supporting information presented by all parties, the guidance issued under Section 182 of the Licensing Act 2003, National Guidance, and the Council's own Statement of Licensing Policy. The subcommittee must take such of the following steps as it considers appropriate for the promotion of the licensing objectives. Grant the application as asked, modify the conditions of the licence by altering or omitting or adding to them, reject the whole or part of the application, refuse to accept the proposed DPS. The subcommittee is asked to note that it may not modify the conditions or reject the whole or part of the application merely because it considers it desirable to do so. It must actually be appropriate in order to promote the licensing objectives. The representation received appears to relate to issues that fall under the licensing objectives. Thank you.
Thank you very much, Maxine, for that. Obviously, we have some questions we'd like to ask. Liam, can I just check on the formatting of how we do this? Are we able to ask questions immediately, or do we hear everything from that?
Chair, I think traditional would be for the applicant to make their case and then gives them the opportunity to address any issues raised within the objections. Or
Chair, with your permission, the normal procedure would be for the applicant to present their case. Questions firstly from yourselves, questions then from the responsible authority, and then, as we're lacking any local residents, I expect the responsible authority then to present their concerns and be questioned in turn.
Yeah, okay. Thank you very much, David. We'll follow that procedure then. So if you'd like to make your presentation, please.
Yes, thank you, Chair. Hopefully I might just answer some of those questions my submissions for you. As well, I've got next to me, I've got Simon. He is the operator and he's the leasehold owner of the premises. And to his right, I've got Hugo, who is an acoustic consultant. So they're here to answer any queries you might have. I envisage I'll be doing most of the talking, albeit when it comes to the technical points, because it's above my pay grade, I'm going to pass over to the expert who's Hugo when he starts talking about such as decimal levels, etc. So just to set the picture, back in November of last year, Simon was faced with two serious problems. Firstly, unbeknownst to him, the premises licence needed for a pub to operate as a pub had lapsed irrevocably due to insolvency of a previous operating company. So as far as we're aware, this is the first break since 1604 that the pub hasn't been licensed. And secondly, the issue of alleged noise nuisance, which he thought had been resolved back in 2021, returned. Now, how does one of those issues arisen just before Christmas, which, as you probably know, is the busiest time of year for licensed premises, and whether they do much of a trade, that would have been problematic enough. But to have two made it very difficult indeed. Now, Chair, as this is not a review application, and because this is not a licence for a Virgin site, and I don't think Mr. Dawson is arguing that a licence shouldn't be granted, I think he just wants a licence granted for set of alcohol and indoor music. I'm not proposing to take you through a normal steps if it's a fresh licence, such as talking about the applicant and going through venues and layout, etc., because they haven't actually changed. Of course, if you have any queries, we can actually answer those for you. Now, Chair, usually, if you're faced with a lapsed licence, what you generally do is straight away you apply for a new premises licence on exactly the same terms as the previous licence. You then got the 28-day consultation period, and what most people do, and what Simon did here with help advice from the council, was to apply for a series of temporary event notices. So at least there's some revenue coming in during that 28-day period. Now, usually it's the case that a new licence will be granted on the 29th day of sort, or occasionally, sometimes the statutory authority says it's a very old licence, we have these up-to-date conditions which reflect the practice, and that's agreed. Conversely, if there is a normal licence in place and these noise complaints are received, it's normally that you sit down with environmental protection, you discuss it and investigate it, and appropriate action taken, often actually once you've had discussions with the complainant and taken readings inside their apartment, flat or house. And these measures could be, you've got a noise limiter, you agree a management plan, that's a sort of preview to review application, or you undertake other soundproofing works. Now, in this case, obviously we were closed for a fair bit of time, and actually works were being undertaken to refurbish the pub, because to add to his woes, there was a serious flood that required the pub to be refurbished. Now, we did ask Hugo to prepare an initial acoustic report, and I know that environmental protection likeness to be fleshed out, but I think Hugo speaks for himself in due course. But to be clear, the readings he took, they were readings taken using the old sound system. So really, the use of that is just actually used as a comparison with any new system that's being calibrated. It's not the situation that will be if this application is granted once the works are finished. So Hugo, can I just pass over to you for a couple of minutes just to explain, because this is quite technical, the sort of equipment you're going to put in, the sort of soundproofing measures that you're looking at.
Yeah.
Also, you're subject to agreeing with the condition with the council if you are with us.
Okay. Yeah, I mean, thank you. Yeah, so, I mean, ultimately, what we'd be looking to do is putting in a digital signal processor, which is a tamper-proof device that can be preset based on levels that we can agree with council. So you can have sound limits in place for input signals and output signals, so signals going to loudspeakers, etc. We can also tune out any frequencies that break out of the property more significantly than others, which is part of my report. I mean, because I wasn't really given any information about where the complaints were, my reading really was to understand what frequencies were breaking out of the venue more than others. So basically taking measurements from around the venue and then comparing that from the measurement from within the venue and then seeing which frequencies are more prevalent on the outside than the inside. Now, the processor will allow me to attenuate those frequencies that break out more than others, which means that there will be less nuisance experience around it. And that's separate from the limits that I can put on the loudspeaker systems installed.
Yeah, thank you. So that's what we're looking to do. I've been trying to speak to Mr. Dawson a couple of times over the last few days. Unfortunately, I wasn't able to get hold of him. We have had a quick chat though just before this hearing, and of course, yesterday afternoon we received his written submissions. So I've only had a brief chance to sit down with my client and Hugo to go through those, but we do have some initial comments to make. I think I'll make a few observations, and then also Hugo, because it criticises his report, it's only fair that he actually has a chance to come back on some of the points raised. So I think the first allegation made is to do with the conversations he had with one of our managers called Jake Jones. This is the first time we were aware of the conversations with him. We have spoken to him. He doesn't accept that he was asked to turn the music. We said he didn't, so he couldn't turn the music down on the first occasion, on 23rd of August 2023. And on the 28th of October 2023, the music actually stopped a couple of minutes after the visit. As I say, this is hearsay evidence. Unfortunately, he's not here today. We're aware of this allegation he made against him yesterday afternoon. In terms of the series of letters that were allegedly sent, unless stated in our written submissions, we have not seen that correspondence. You'll see they were sent by post, simply addressed to the occupier. Now, all post that is sent to the premises is put in a duty bag and sent on to the accountant to sift through. We check with our accountant, and he's not aware of those letters being received. What we would say is that back in 2021, Simon was very keen to be kept abreast of any issues personally, and he did actually give out his mobile number and his email address. So we would just ask, regardless of what happens at this hearing today, if any correspondence be emailed to him, so it comes to attention straight away, that would be very useful. He's got all the DPS and the owner operates the premises. In any event, we say that the letters, I think they're standard letters, they don't give any details of the allegations. By reading them, we wouldn't actually know what day or time that the alleged nuisance took place. And we're not aware, it doesn't look like any of these complaints being witnessed by an officer. It just says they've received a complaint. It doesn't confirm whether they've witnessed a complaint themselves. There's 7 in total, and obviously 7 complaints of any premises is 7 too many. But we say that it's not exceptional over a period of 4 or 5 years. When it refers to the decibel levels, and I'm going to ask Hugo to address you because he knows more than me. But what we say is that the recorded levels on nearby streets, it's often very high indeed, into the 80s, even when the pub is closed or not playing any music. And in particular, on one of the days that the complaint was made, and this is a complaint made at 0:55 on 11th November 2023, we were closed. We didn't actually open at all that day, and yet there's been a complaint that's been logged against us. Now, helpfully, we've got this map that's been produced, and you'll see that we've got 2 complainants. Again, sometimes when I have environmental representation, I've got 50 local residents booing, hissing me from the stands, but we haven't got any residents here today, unfortunately, so it's a bit difficult to go into their concerns in much detail. You'll see one is some distance away, that's a 5-minute walk away. I don't think realistically they could actually be personally affected by any music of venue. The other premises is nearer, but we say there are other licensed premises in the area, in particular Canton Cocktails and Roof Garden, which we say is probably equidistant or maybe actually nearer the residents' properties, although we're not sure exactly where they live. And certainly the nearest residential block in question is actually at a right angle to where the music plays. So again, this is speculation because we haven't given much detail, but certainly that one complaint is definitely not us because we weren't open, and we can't say for certain the other complaints are definitely due to the pub in question. We don't know what exactly has been experienced by officers. It seems that a lot of this information has been gathered by the resident in question, who isn't here today, and they have decided when to turn on and turn off the recording equipment. Again, Chair, I'm sounding a bit vague because I haven't been given much information to actually go on myself. But as I say, at the moment, we're genuine concerns that some, if not all, the complaints are not due to us. And certainly the conditions that have been suggested at the end of the written submissions, effectively that's saying, well, let's just give up altogether, just have no music at all. What we're saying is those conditions actually don't give us a chance to prove ourselves. And what I'll explain in a second, but with our conditions, we believe that it's a compromise that gives ultimate protection to local residents and also the environmental protection. Hugo, I'm just pass on to you for a couple of minutes. I know you were very keen to address some of the points this is made by the report.
Yes, no, it's just a clarity really. So on the 3rd page, it comes to my report on the issues that were drawn against it. So I just wanted to address each one of those points individually if I can. So the first one, it says that there is no information in the person producing the report, nor there's been qualifications. The reason for that is that none of the reports that I've read in the 15 years of working as a professional in the industry contains that. I'm happy to provide it. It's not. Sorry. Yeah, I'm happy to provide that information, but I didn't deem it necessary to put it into the report. But I'm more than happy to provide it, so no problem at all. The second point, reports not state what assessment method is being used to correct them. I'm not sure what this question actually means, so Tom, if you can clarify what you meant by that statement, then I'm happy to answer it. There's no description of the public main sound sources. It's the sound system installed in the garden, which is mentioned in the report. There's no mention of equipment being used and calibrated. I have the calibrations with me today, should that be required. There's no description of surrounding properties, what type they are. As I said before, it wasn't really part of my reading to do that. I was more looking at noise breakout. because I didn't know where the complaints were coming from. I was really trying to understand better which frequencies might be causing problems rather than assessing what the buildings were being used for. It doesn't contain a method of calculation to estimate noise levels to the nearest noise sensitive premises. It's very difficult to do. Values will probably be irrelevant because I don't know what, if they're double glazed, what kind of insulation they have, etc. And then the other two remaining points I can provide that information.
Okay, thank you. So, Chair, we believe that the route we've suggested is the correct way forward. And essentially, it means that we work with environmental protection, and once we have installed the necessary equipment and taken the necessary soundproofing measures, we have a site meet environmental protection. Ideally, with two officers, one is actually in the pub who can record what music's being played and what volume, another officer who's in the resident's property. Now here we've only got one resident, so it's not that complicated, but would normally be the case is that noise limiter is set at a level that means that there's no noise, no such a nuisance being caused in a residential property. Now of course, if this was a normal application, if there was a variation, for example, we never had the ability, which we've had for years and years to have music outside. At this stage, I normally would have asked to adjourn the hearing, and let us actually put all the equipment in, etc., and then we'll come back to you. Unfortunately, we haven't got this luxury. We're very squeezed for time. It sounds dramatic, but realistically, if someone can open the doors and at least pour a few pints soon, I think we'll be posting the keys to the letterbox and walking off into a distance. We say that as well as proffering a noise limiter condition, which my business commission, hopefully that will solve matters once and for all, because it will be set and tamper-proof. But we've gone further. We volunteered a terminal hour for use of the garden for music, which wasn't on licence previously. It was 1 o'clock previously. We've proffered an hour of 10 o'clock during the week and 11 o'clock at weekends. We've also proffered a condition to keep doors and windows closed when regular music is taking place. And also to have a number available to residents, so if you can contact someone directly, you can sit down and talk to them about any issues at all. And all these conditions, Chair, and it's 4 of the written submissions, I would just stress for record that because it's going to take some time to actually install the equipment, that these conditions, if you're minded to grant, using our suggestions, only apply once the equipment's been put in place. But of course, we'll have no music in the garden until that's done. Because he's very keen to actually start implementing to release for sale of alcohol. So the alternative, is if we go an environmental health approach, is that you grant the licence for inside music and sale of alcohol, but you say, no, we're not going to grant it outside until you've actually installed equipment and taken the tests. Now, the risk of that approach is that it's going to cost approximately £30,000–40,000 to do this work. And what someone would have to do is lodge another application, so you've got the application fees, the legal fees, the advertisement fees, and the payment of 30–40 grand, etc. investment. And then committee, you might decide to refuse the application, in which case that money is down the drain. And if you're minded to grant, if representation is received, that's still another 8-week delay. So just to wrap up, I'm sure Jay will have questions. We say we have sought to engage with environmental protection. We hadn't been aware of some of the issues previously. We are now, and there is ongoing dialogue, and regardless of what's decided today, we'll continue that dialogue going further. The investigation and rectification process, it is still ongoing, but we say with conditioned profit, it gives the protection required and places far more checks and balances on us as the operator. And finally, just say, Simon, he's not a faceless large company, not dealing with a large brewery here. He's not an ogre. He is happy to sit down with any residents if they have concerns. But conversely, it also means that if music can't be played in the garden, it will have a devastating impact on the business. And what is a small business, a one-man band. So we're not a large company that can just actually sustain these losses. Therefore, Chair, I urge you to grant it as sought of our suggested conditions. I don't think there's anything more to say at this stage, is there? I'm getting a shake of the head for right. So, Chair, I'll leave it there, but also happy to answer the question I have, and I'll come about some of the other issues raised later. Thank you.
Okay, thank you very much, Mr. Camp, for that presentation. We've got some questions at this stage. Apologies. Yes, this is about noises behind us. Yes, we have some questions. I think we'll ask around what's just been said there. Then we'll perhaps get to Tom Dawson, the points he's raised. I do know that there's a clarification that was given to you, I think, around that. Come on,
Thank you. Mr. Clan, you mentioned the incident with Jake Jones, the manager, and the DJ, and that the DJ didn't turn down allegedly the music. So my question is really, I suppose, to Mr. Peters, which is how much the manager and you, and it's a sort of clarity really, understand your responsibilities in this area. You know, if you could just, you know, talk a little bit more about that would be helpful. Thank you.
Yes, in terms of like what our responsibilities are as an independent operator, we host a number of music-based and music food-based events at the park. Now, Last Pub Standing is essentially a grassroots venue that gives that platform and the ability to perform for small independent artists, bands, DJs, etc. Now, to those who would not ordinarily have the opportunity to play in front of a live audience. Now, I take my responsibilities with regards to managing that business very seriously. Now, in 2021, on a visit from Mr. Dawson's colleagues, I had a very positive, long, extensive conversation with Environmental Protection because of some of the modifications that we'd made to the garden. Off the back of that, I came away from that conversation very informed about all the little things that I'd missed and perhaps potentially little tricks that I could put into place to ensure that the lack of nuisance or noise bleed, as it were. Now, at the same time, I did ask Environmental Protection to come to me immediately in the event of any situation, because the business partner that I had was a bit wayward and would perhaps nod and say yes, but what you just said, so not being filtered in. And I was in the process of training a relatively new experienced management team, so I didn't feel it would be fair on them to thrust them straight into dealing with public authorities, having only just recently qualified for their own personal licence. So for me, I believe it would take 3 to 5 years, and I stated this at the time, in order to train these two individuals up to a semblance of competence where I would feel comfortable as a business owner, allowing them to interact directly with the authorities, so as to avoid situations or miscommunications like what appears to have been experienced. My stance is if the music is sufficient volume to cause a nuisance to a resident in their own home, and they call up, email, send a message through Facebook or any of the social media platforms, or even attends the premises face to face, my expectation is if that resident has taken the time to say it's too loud, then it gets turned down. And so both my managers know this is my stance, and so I'm a little confused or concerned about an allegation where my assistant's been told, oh, turn it down, and people say no. That's generally not what I expect him to do. With Last Pub Standing being close proximity to some of the local residences, it's a symbiotic relationship. There's a lot of people in the surrounding area that does use Last Pub as their local. They do go there for food, they go there for drink, they go there for the entertainment. And so if one person is unhappy, that's one person, that's one complaint too much. And so I insist on my management team do react appropriately. And what has also been prompted as a result of this is review of our internal policies and procedures with regards to receiving voice complaints and what my expectations are should I not be present and should a member of the authorities be in attendance. I want them to at least have an understanding of what they're allowed to do, what they're not allowed to do, and for me to be immediately brought to the review. I think over time this is quite been the case.
Now, I think hopefully one thing that comes through with the written submissions is that when Simon's been actually contacted directly, he's dealt with the issue. Back in 2021, it worked very well. There's proper discussions, dialogue. It was all very collegiate and it got sorted. And I think the issue is with these more recent complaints, the only time it's actually probably come to his attention is when he's being told, by the way, you've got no licence at all. I think this is, it's devastating. He's got a flood, he's refurbishing the premises, he's trying to get through the Christmas period, he's got a noise complaint, and the licence is lapsed. Even so, he's actually engaged. So hopefully you'll see that when he is actually brought to attention, it is actually done with.
So my next question is, just following on from that, obviously you've got a management team in place and you're training them. So you're obviously not on the premises all the time, they are there. And you are obviously training and talking about the incident that took place and putting in measures, as you said, and as we're reading, to make sure that this kind of incident wouldn't happen again and that their understanding of their responsibilities is there. That would be, without giving you reading.
Yes, that is correct.
I think, sorry to interrupt, with the noise limit condition, the great thing about it is it doesn't require any judgment on behalf of any system manager or manager. It's sealed in conjunction with environmental health. They can't turn it up or down, they can turn it down, they can't turn it up.
Okay, thank you. I did have one query that arose when we said this at McCann. Can I just check so that if correspondence is sent to the pub, is everything then forwarded to the accountants?
Essentially, when I'm there on sort of a morning shift, opening up shift, taking all stock deliveries, cash desk administration, etc. Any post that comes through will be opened there and then. It's post that happens in my absence, and that will generally be set aside for being opened by the accountant. So I'm there, quite correct, I'm not there 24/7, but I do make myself on site to make my presence known at peak times, but obviously there's going to be times where it's not feasible for me to realistically be there unless I'm actually burn out but in the instances where I'm not there daytime, then that post is collected and sent over to the accountant every 3 days.
I mean, Chair, to be clear, we sent our written submissions, we received some of those, we haven't received some others. I'm still waiting for a credit card to be sent to me, because that's been sent 3 times in the last month. So what we would say is that whilst we're sure the council sent the letter out, please let's not rely on very old-fashioned posts where you've got a phone number and an email address, which is far more reliable.
Yes, certainly we can take that into account. So you might, Mr. Peters, not be there for 3 days, and then the final post will be sent to the accountant.
If I'm there, if I'm present, and the post is made obvious that it's there, post gets opened. It's just that as a fail-safe, in order to ensure that nothing gets missed, then that post will be put aside along with payment receipts and invoices, dispatch notes, etc. from suppliers, and that will be handed over to the accountant. So, say a letter was sent in the post from council to myself. assuming you posted it on Monday, then the absolute latest it would get to me on the proviso that it's delivered the next day will be perhaps Thursday or Friday. So it will be received in the same week. There's not that much of a lag or a delay between that post going to the accountant and the accountant opening up and going, oh, by the way, Simon, you've got a letter from the council, you need to have a copy of this, you need to address this, etc. So
I think one thing, we don't know what happened with these letters. One thing is clear that in 2021, something was brought to his attention, we acted on it. So it's not as though Simon's a sort of character who just ignores correspondence or puts his head in the sand. It doesn't.
Thank you. I'd also just like to clarify the email that you sent on the 4th of January. That has 6 bullet points in it.
Yes.
Just for clarification, are you offering those as conditions here that supersede what we received in the pack on page 27?
So, Chair, on page 27, these are the conditions that replicate those that are on the current licence that lapsed. I can confirm the bullet points in my email on 4th of January. These are conditions to be formally proffered and from a licence if you're in agreement, subject to them only applying once the work has been carried out and completed and looking to set. And again, with the proviso, which we know outdoor music until those steps have been carried out. Because strictly speaking, Chair, if, for example, there's a noise limiter condition based on a licence you grant today, we couldn't even trade until we actually get that noise limiter installed. So it's more of a legal issue. I don't think anybody actually calls an issue, but just to be clear on that one.
Okay, thank you for that clarification.
Thank you. Yes, the question to you, Hugo. We've got this big document here, which is the very technical document. So hopefully you could summarise it for us. For instance, it mentions something called pink noise. Unless I know nothing about pink noise, but I'm sure I will.
It's basically all, it's 20 hertz to 20 kilohertz equal energy, so it's basically a test tone that covers all frequencies that you can hear, sorry. And that's so it's a way for measuring, it helps me measure breakout from events because all the frequencies produce equally. So within the venue, through a sound system, and then if I go outside, some will be attenuated more than others, so I can work out which frequencies exit the venue more than others, which allows me to then preventative measures in to reduce that breakout for those frequencies. So those will be the frequencies that your complaints are experiencing.
So I should have clarified, this is what Hugo does as a living. The reason why he's stressing Sydney is he's about to go down to Brighton Football Club to test their sound system. So he's done many of these reports before in some fashion.
I've got a supplementary on this. So if you could explain as well how this came about. Was this commissioned by yourselves?
Yes.
And why was it commissioned?
It was the recommendation of environmental protection. I think in their submissions, when it first came to light, we were advised to instruct an acoustic consultant. And also, Hugo was involved, regardless of what happened, because we had the flood, we're installing a new system anyway, and Hugo's in charge of that process. So he's already instructed, but then he's asked to go further and produce this report.
Could I just clarify as well, as far as being referred to as an acoustic consultant, that isn't actually my job title. I have a degree in audio engineering. I've got 15 years working as a professional in the audio industry. I have the test kit because I rely on it for my work day to day. I'm mainly a design, commissioning and programming engineer for audio systems, but that does entail a lot of acoustic measurements, particularly for large projects like, for example, the stage work that I do.
Another supplementary. So yes, you asked to do this as a result of communications from Norwich City Council Environmental Health. what did you know about what had been, why you were having to do it? For instance, you said that you didn't know where the complaints had come from, which kind of, forgive me if I put words into your mouth, but I got the impression that you may be a little bit hamstrung by the fact that you didn't know where the complaints
That's
were
correct,
coming
yeah.
from.
So I wasn't fully aware of, I was made aware of there's a small quantity of complaints, but I wasn't aware of where they were coming from, which properties, which is why it's quite broad in terms of, in terms of the information. I mean, my measurements really are to determine which frequencies are escaping from the venue more than others, so I can then put preventative measures in place rather than, typically when I've worked with council on this kind of thing, I have been in the properties, I've taken measurements while the sound system's running, and then dealt with the complaints directly, which makes it much easier to put these preventative measures in place. But this is really more diligence than it is anything else, because I was working with very little information about, what I was trying to reduce in terms of all the frequencies.
I mean, just to clarify, we still don't know much of the detail. Hence, my submissions were somewhat vague at times. And so, in our experience, when there is a complaint from a single resident, normally the first course of action is to actually try to get the complainant to meet with the operator and ideally actually take tests inside their apartment. Occasionally, you might have a complainant who says, I've been in many times to the pub and I find it intimidating, but here we're not aware of any of that. And Simon's not scary. So yeah, that's why we're slightly limited in terms of what we can produce.
And finally, that's a question for any of you. You couldn't find a date on it, but when was this survey measurement carried out? If you could tell me, thank you.
29th of November 2023.
So we.
About 3-1.
Yeah, between midday and 1 o'clock on the, was it 20?
Would be Tuesday. So it's
Turn my phone off first.
Again, I'd have to start looking from it. We did actually advise the council tests were taking place because we didn't want to crank the music all the way up and make a noise complaint. We're actually doing the test, so I think it's around that time of November.
So that's fine. I don't need to know exact date, but just kind of, for context, roughly when it was, but late November 23. Thank you.
Okay, thank you. Just one further question on the report. On page 8, we've got suggested resolutions here.
Yeah.
I'm not sure I fully follow some of the technicalities of this, but I particularly wanted to clarify the last paragraph here, should further solutions be required. If a noise limiter is being put in and agreed, do you feel that would then need to be recalibrated? Is that what's being suggested?
Well, I mean, I would be taking measurements again once the system's installed to make sure that I'm actually, the device is doing what it should do. That's just diligent. But there are further suggestions there that require more time, more labour, and specific design requirements, which we might not need, but should they be required, then they'll be undertaken as well, which is more to do with the base traps.
Chair, I think, and obviously Mr. Dawson will be able to clarify, he's the expert here, but in my experience, what normally happens is once we've installed the equipment, we think we're ready to go, we contact Mr. Dawson and his colleagues, ask him to try to come down for his convenience. Then there's various noise tests that are taking place, a limit is agreed, and then the system is synced. Now, it could be that if our soundproofing is very poor, that limit is set so low you could barely hear it even we hear it empty speakers. And it would be then up to us if we wanted to then ask his colleagues to kind of recalibrate, do further attenuation measures, and see if they could come out. But basically, it gives complete control to environmental protection. Obviously, if he goes there, there might be some disagreements and the speakers might be tweaked in some way. It's very much a collaborative approach. Once it's done, it's done.
Okay, thank you. Are there any other questions at this stage? Sorry, can you do that?
I suppose this is really a question for you, Tom, but I mean, would you at any point make any approach to the people who have complained to see whether what you put in place helps them, or is that left to environmental to do? Thank you.
So, in our written submissions we circulated last week, the residents now have my email address and can contact me. We'd love to meet them. Unfortunately, we're not here today, but generally speaking, I mean, with all due respect, with something like this, a subcommittee hearing, it's often not the right forum because it requires actually meetings on the ground and tests being taken place. But because of GDPR, we're not being told who this person is. We would really like to know.
Okay, thank you. On that point, perhaps if we go to Tom here, there was also just a note of a query from Hugo that you were going to clarify.
Yeah, come on, point 2 on page 3, or the second bullet point. Okay, so in regards to assessment methods, what happens normally when we get complaints from commercial premises from residents nearby is acoustic consultants normally will do assessments based on the British Standard Method, which is BS 4142, which basically is the standard for assessing the impact of noise inside someone's property. Part of that takes into account World Health Organisation guidelines, which sort of give an idea of what noise levels should be inside a property both day and night. They're the sort of things I'd expect to see in a report that's dealing with complaints from residential premises. I appreciate they didn't have the address of the complainant. Common council procedures, I don't go around giving out complainants' addresses, not best practice. But given the location of the pub and what's found, it's not hard to see where the nearest residential properties are. There's a kind of accepted level that when I go into property, I'm not going to know what the acoustic properties of every single pane of glass is. Not property, so it's kind of a given that most normal windows apply about 15 decibel attenuation as long as they're outside. Nighttime noise levels in the property is ideally around 30 decibels. So what we then say is outside the nearest residential premises, the noise levels need to be about 45 decibels. All that's contained in the BS 4142 assessment, which is kind of what we go for. It may have been my fault as discussed getting the noise assessment done, that wasn't specific enough. So it's the first time we've seen them haven't had that assessment.
Okay, thank you. Are there any other comments that you wanted to address?
I think that quite a bit has been said about the letters being sent out and trying to contact Mr. Keith directly. Regarding the letters that are sent out, they are automated. So as part of the council procedure, when we receive a noise complaint, it comes to the contact centre, gets put onto our computer program, and the letters are sent out directly from the contact centre. I don't know what the procedure is to try and send things out by email. I don't know if it's a possibility. That's something we can look at. But it's standard procedure for letters to be sent out to the address of the premises that's being complained about. Obviously, we can't control the post system, but there's procedures to go out to the address given to us as our system at the time of supplier. Even though he's actually requested for emails to be done, to be sent by email, that's why they still typically sent out by post. My only other concern is obviously Mr. Peter mentioned not being aware of the complaints, of the letters being sent out. He's obviously spoken to colleagues previously, so he's obviously aware there have been issues there before. The only comment I'd make regarding the suggested conditions that Dr. Sanders has submitted, normally I would be happy to go along with kind of conditions of this nature. My concern is that on the temporary event notices that they're operating on over November, December into the new year, part of the condition was obviously if we received any further complaints, there would be nothing taking place in the garden, being moved indoors. The complaint was received on the 29th of December. Unfortunately, it was when the council was closed for Christmas, so we couldn't act on it until we got back. The fact that obviously we put tighter conditions in place, the complaints are still being received. I'm loath to agree to conditions for use to be outside. I'm not trying to stop them running the premises completely, but given the size of those 2 floors in that property, they could be used for acoustic events, but it would be necessary to risk causing further nuisance to the residents outside.
Chair,
to the nub of the issue. So, with your permission, Mr. Dawson, can you assist regarding the level of detail of the complaint of the 29th of December, which is code for, can you say was this premises or not? Have you any more data?
Yeah, so obviously I haven't included in the report, but the contact I got from the complainant on 29th, about the 29th of December included a video that was taken from my flat that shows the dog garden in use and the noise coming from that premises.
Secondly, the committee will need to consider with the 6 bullet points on the email of the 4th of January, and I need to be clear on your evidence that you would normally be happy with such proposed conditions. Can you give assistance to the committee as to why you'd normally be happy?
Because when setting conditions for licensed premises, especially in residential, we try and restrict outside noise to not occur within what's classed as night time. So once again, going back to the World Health Organisation, they deem night time start at 11 o'clock in the evening. So we generally ask that anything outside is stopped. Then, kind of ideal world, you like levels to be reduced because you get to 11 o'clock, so people want to work evenings. And using a noise limiting device would help, but that's the fact that there were conditions on temporary bend notices to negate the, or to limit the impact, and we still receive complaints. I can't see that this would help anyway now. It's not to see any complaints in the future.
So that's specifically the first bullet points there.
Yeah, essentially, yeah. So obviously, normally if we hadn't received the complaints, we've been happy for the entertainment to stop at the time suggested. The fact that complaints are still being received, I'm going to go on conditions, so not an issue. But obviously, if there's not regulated entertainment in the garden, it becomes somewhat of a moot point.
One time, if you can, where you informed that, because I understand this is, where you informed the complaint was being introduced on the 29th of December.
So I received the email on the 29th of December. I picked it up on the Tuesday, 2nd of January, from the town Christmas.
Sorry, I may have been unclear. Do you have any data as to when it is said the event was happening?
I can find it. I don't know it's very time, but I can read the emails and get the times that the call was taken.
I think that would be useful if you were able to. Sorry, that would be useful if you were able to provide.
Yeah, give me 2 seconds, I can get this.
Chair, I don't know if you wanted a 5-minute break versus no wish.
Yes, yeah, okay, we'll take a 5-minute break. Yeah.
Yeah.
Okay, thank you, everybody, and welcome back to this regulatory subcommittee. A couple of questions that we perhaps like to raise at this stage. So we've had a suggestion of music not taking place in the garden. Could you respond to how you feel about that circumstance?
Chair, I wouldn't be here now, I don't think, if we were happy not to have music in the garden. It's essential to the business. It adds significant square footage and covers. Given that the premises is not on Prince of Wales Road, it's not on a major thoroughfare, we don't have much passing trade. And with the state of the economy at the moment, to be perfectly frank, and no doubt the purpose before, but this is general, I don't think we survive if we could put any music in the garden. Yeah, hopefully that answers that question, Chair.
Yes, thank you very much. On the conditions that we're now looking at, included in the 4th of January email, which you confirmed would be put forward as conditions. Can I ask firstly how the telephone number will be made available to residents and businesses in the vicinity?
There's various ways we can do it. We can let a drop, we can have a sign up of the premises, we can have telephone numbers. Council already have it, but we can give permission for environmental protection to give out our details. The 2 residents in question have my email address, they can contact me. We're very happy to have it available to whoever actually wants it. So they're just some suggestions, Chair, but if you have a particular request, of course, we're happy to adopt it in terms of communication.
Okay, thank you. Also, the anti-penultimate point there, except in instances of technical failure, which will be reported immediately to environmental protection. Noise emitting devices on site cannot be reset or adjusted without consultation with the local authority environmental health officer. It does suggest that the environmental health will just be advised of what's happening when it says in consultation with. Could that be on the authority of the environmental health officer?
Sorry,
I think that the caveat placed on that point was based on the fact that that building being quite old, I do on occasion suffer power failure, which
I think it's a different,
if you've got
a different point. I think it's the wording, isn't it? About
Yes,
it's the second
it's the wording
about condition.
The consultation with the local authority environmental health officer would be my particular concern.
I mean, ultimately, it's got to be set with environmental health and sealed with environmental health. So we can certainly have, at the direction of environmental health, acting reasonably, or worse to that effect. Again, Mr. Dawson, we're very happy to work with him, but if he suddenly were to move on, somebody else comes along and just says, I don't like this at all, I don't agree with the committee's decision, and just says, I'm not going to set it, that's the issue. Perhaps your legal advisor might be able to assist in sort of running better than I can.
David, what's your thoughts on this circumstance? Consultation with is, from an enforceable point of view, tricky. Consultation could mean an email, not a word, so that needs tightening up. I'm aware it is also one of our set conditions, by the way.
Yes.
That's probably where
I got it from, yes.
Yes, so flagging that with apologies, but consultation with is forwarding and needs rewriting to state who has the last word, basically. And that will be a decision for itself.
Sorry, there's actually conditions before that.
There is. They don't sit well together.
Yeah.
I agree with you that it's a noise limit to be done is set at a level agreed, and therefore if there's
We can't
agree
agree
no
with
agreement,
conditions.
then we never get to set it, which is another issue. So again, it would be boiling down to this committee having to decide who sets it. If there's no agreement,
bullet point 3 won't ever occur. So therefore, they're going to have to rewrite that as well, I suggest, if they're happy to proceed on the state basic framework.
Again, Chair, I go back to my point earlier that technical matters such as this require teamwork and actually working with environmental protection and a bit of common sense. It's very difficult, but it's a practical step that's going to be taken to actually have an all-encompassing condition. Ultimately, regardless of what condition there is, if we are reckless, Mr. Dawson, what's called, can always review the licence, and we'll probably have a completely different sort of conversation.
Absolutely, yes. It could be reviewed. At the direction of, I think was suggested, David, would you be happy with that wording?
Chair, I suggest it's a little early in the committee to be coming to views across the entire principle of the application still to be decided. When we get to the end, if you're happy to proceed with the draft condition as we suggested, then we make a decision as to who gets to control things. If the council is reasonable, there's always judicial review, there's always the ombudsman. It is, it's going to be a future decision for yourselves, depending on early decisions.
Yes, absolutely. This will be something we could arrive at.
Yes, Joe, it would be imposed and therefore subject to appeal if we get to that stage.
Chair, it's completely, of course, up to you and a legal advisor, but sometimes in situations, I find it useful that if the decision is to grant with conditions, that myself and the legal advisor, whilst you're determining, can actually sit down and maybe draw something up rather than doing it on the hoof, actually during the hearing itself.
Yes, I'm sure that will be acceptable. I think we've done this in the past. Okay, thank you. I'll pass it to my colleagues.
One or two questions. One was going back to you, Mr. Peters, if I may. You were talking about the noise issue that you had back in around 2021, or I imagine leading up to 2021, because you actually said the noise issue was resolved in 2021. You thought it had been resolved. I'm just wondering if you could, it'd be helpful if you could flesh that out a little bit more. What was the noise issue? How did you think it was resolved? And why do you think it is now an issue that we're discussing today?
To put things in context, Councillor, when two of the gentlemen from Environmental Protection attended the premises back in 2021, we had long and in-depth conversations, discussions back and forth, along with Michelle from the Police Licensing Liaison Office. So we had a bit of a sort of 2-3-way conversation about noise pollution, how directing the speaker in a particular location at a particular angle at a wall, will reflect sound one way whilst reducing or attenuating the sound on the other side of that. A bit like playing snooker or pool, perhaps, would be the simplest analogy. But also with things like placing a marquee, being mindful of the material of that marquee is a consideration, which is something that is simply not really appearing on the radar, so to speak. It's a case of like, okay, well, we have blue here, we have greenery here, we have a nice big trellis here which blocks and encapsulates a lot of the sound, it keeps it within the garden, it doesn't escape into the sort of local area. And also back in those conversations, we started to install what's called a sound trap or bass trap, which is often made of material fairly similar to loft insulation. It's fairly dense, industry standard, and it's used particularly for screening out, filtering different frequencies. So I've put some generic traps up along the back fence of the property. It was hidden behind some lovely bamboo and then had plastic screens in order to keep water in the flower bed and not spill out the benching. And that appears to have reduced sufficient sound and vibration bleed from the property to the point where no further complaints have been received either by email, over the telephone, or from the office of EHO. So I believe the issues have been resolved by the fact that no one was really going, hey, too loud, it's too noisy, you're too disruptive. On the basis of that, what we put in place, obviously was working to a degree that everyone was satisfied. Live music finishes at 10, pre-recorded music finishes at 11, sometimes midnight. We've got the limited equipment that we've been using historically, and that seems to really cause too much of an issue. No one was even contacting us directly to say, you're too loud, you're too noisy, or we don't like what you're doing. In one complaint, there's even someone going, hey, look, I know you guys stop at 10 when you're doing live music, we do acknowledge that, we appreciate that. But could you do something else to mitigate some of the noise? And that was then enacted. And that was around the time that Environmental Protection had attended premises to say, oh, we've received some noise complaints. What is it you do? Oh, I've got a 9-point sound monitoring sheet, which I have a handheld decibel meter. You take readings from front of the speaker, inside the premises, and at several points around the perimeter of properties, including just in front of the apartment block on Great Rise. So we do try and make sure that whatever noise is being made inside the garden, we make sure that we are keeping that to a relative level, which is why I hope to know what the background noise levels are in the area, because I'm always out there with the sound meter taking measurements of this is how noisy it is now. There's no one on the street, there's no car driving by, and we've already put the music on, and it's X decibels.
I think this is why we didn't have the outside music when we had the tents in place, because the decibel level that was set was actually lower just than the ambient decibel levels on our readers. So even before we played any music, just normal streets, it would have been above it. So that's why the tents we had in place weren't really worth the effort, because we couldn't use it anyway with the condition.
So the recent complaints have been more about live music, DJ played music within the premises. Is that right?
I think the final complaint just before we rose, the final issue was to do with a temporary event notice late last year, where we didn't have any music playing outside, we didn't have music inside. We had the door stop and Simon was monitoring the door. Now, as far as we're aware, there's been no officer who's witnessed a statutory nuisance from that night. Apparently there is a recording, which we've not seen, that alleges that there was music activity coming from a park. There were people in the garden having a drink and smoking, no music was being played. What I would say is that when I act for local residents, I have to explain to them that you can't simply lodge 30 complaints and get the pub closed down. Complaints have to be witnessed by a qualified officer. And also, we believe, what's been said today, is that a video was taken on a mobile phone. I always disappoint local residents when they say, look at this lovely iPhone video I've got. I say, it's not acceptable because iPhones are designed to accentuate the noise. And that is why officers have very expensive, very specific equipment. As far as we're aware, that wasn't used on the day in question. So I would say that there's only limited evidence, there's only limited weight to be put on that complaint on the 29th of December, and we've been trading like this since 2019, and had it been an issue, we've been getting complaints every single day of the year. But we've only, as far as we're had 7 over the course of 4 or 5 years.
Okay, thank you. Just to clarify, the bass trap that was put in, was that a response to the 2021 complaints that we received?
That was wasn't in response to directly. I was not asked to do that. I took it upon myself as I considered it to be a responsible and a reasonable course of action to take. on the basis that I don't really want to be worrying about whether or not what I do in the garden is going to be upsetting the resident in the previously own home. So I voluntarily, like I say, took that upon myself to put that in place, and for the most part, it works. Insofar as there is no evidence to the contrary, up until the point where this year, around the time that there was some very, very heavy rains, which caused damage to the garden, and after investigation it became apparent that part of the material had become damaged and was therefore never used. So it's been removed, so the garden is now there. So when the standard survey was taking place, it's right, this is almost like virgin territory. There's no protection in place, there's very little to stop the noise from being encapsulated. Right, let's see what the natural breakout is, what frequencies are travelling from this premises to outside. And that way, in conversations with Hugo, it became very difficult to propose just a generic solution. It's right, let's see what frequencies are causing the issues, what are the relative volumes, what are the sort of symptoms that the residents are experiencing. And the final solution for with regards to sound insulation for the garden will be put in place based on those readings and consultation with environmental protection. And if the residents are prepared to sort of work with us on this, go, right, okay, well, we will permit entry to our property and sort of take the readings, and we can then positively identify what issues are being caused, and if you need it, it's not I'm happy to extend that gesture to work with the community as opposed to feel like we're at odds with our community.
I think that probably covers it. It's a very long answer.
Thank you. So the screening you're saying does seem to have worked previously, but that's damaged by the bad weather. Is that going to be put back in place then?
Yes, we are looking to put that in place, but that will be in conjunction with Hugo and the ongoing configuration management of what sound travels, what doesn't. So it's very difficult to sort of put back in place something that was custom built. If we're going to be making some changes, because those changes may supersede some of that equipment or some of this.
Chair, can I just add that it's in our interest to put in as much soundproofing as possible, because simply put, to a layperson, the better the soundproofing, the higher the level can be, at a level that both patrons can actually enjoy and disturb residents. But with the noise limiter, it's slightly academic really, because it's up to us as to how much we want to do to see the level we can actually get.
Okay, thank you. Are there any other questions?
I've got some questions for Mr. Dawson. First of all, we took a break so that you could find the email that you received over Christmas, but obviously didn't see until we were back on the 2nd. Did you find it, and what comments would you like to make about it?
Yeah, so 3 videos were received from the complainant. Times on the video, timestamps on the videos were 6:14 p.m, 10:59 p.m, and 11 p.m. Seconds. There was one comment there that after the third timestamp of 11 p.m, music that was being played increased right after 11 p.m. But no further videos required. Just to respond to the comment regarding obviously video sent in. When videos taken on mobile phones, obviously mobile phones can recommend what is being heard. So it picks up most what they think you want to hear. Essentially, it's not always what human they would pick up. So we wouldn't use them to take enforcement action. Prior to those videos, back in I think it's the beginning of November, we did install calibrated sound recording equipment into the complainant's property. Proceeded that is that stays in place for 7 days in their property, and the equipment constantly monitors sound levels within the property. So we will see over a 7-day period what sound levels are at day, night, where it's going. We can only hear what is happening when the complainant pushes the trigger to then start the equipment recording. Obviously that has been installed, recordings were made, which then why those submissions to the abatement notice is also issued. Can't allow music from the premises. So we have installed the equipment previously, but because we're closing Christmas, we obviously couldn't put it in again for the straight month.
So just to clarify, the evidence from the video submitted is not admissible evidence.
You could use it if you want to, it's not best practice.
Not best practice. And this complainant has got equipment installed in there
Not at the moment, so it's been installed previously.
previously,
It has been
but they
installed.
weren't able to trigger it on this occasion. As well as the videos they sent, what else did they say in their email?
So just describe the video that they've zoomed in, you can see movement in the garden.
It's a little unfortunate to have evidence that only one party can see.
Mm.
Is it
I'm happy
at all
to print
possible
it.
to have this
I can print it off.
Yeah.
subject to the applicant? If I was the applicant, I'd be keen to have rather than what I've got at the moment. Would that be fair?
I don't require my consent, I'm happy to see it. I'm happy to see it.
Can you
See what we do?
Yeah.
If that can then be printed off.
Yeah, I'll do it.
Yeah, whatever we need to do to have that data widely distributed would be useful.
Yeah.
Great.
Okay. Again, if we perhaps take a 5-minute break for that to be done, and we can see.
Chair, as you know, the rules of hearing notice any additional evidence should be with the agreement of all parties. It's also been discussed about the relevance of anything in addition. It appears that matters relating to the 29th of December are not considered particularly relevant to the decisions you're going to have to make. And it is suggested now that the data is not provided to you, it being irrelevant.
Okay, well, thank you, David. We're happy to follow that legal guidance. Are there any further questions then?
I'll just continue with my questions, do just a couple more. One was we heard that there was a logged complaint, I believe it was the 11th of November, and we heard from the applicant's representative that it was a day that they were actually closed. So I was just hoping to seek some clarification on that, what comments you can make on a logged complaint on a day that they were closed. If you
So
can.
the 11th of December, did you say?
I've written down the 11th of November. It might not necessarily be the date, and applicants may have the date because it was raised by yourselves. 11th of November, somebody complained on a day they were closed. So I hope for some more details and clarification on
Obviously, police attended, I attended with one of my colleagues on the 9th of November. Police were in attendance on the 10th of November, where they were still trading. We were also advised that Mr. Peters told us that he intended to trade on Saturday, 11th of November. The sound recording equipment was in at the time. I don't have the data what days the recordings were made with me. What times there, but there you go. So, yeah, sound recording picked up a noise over 52.5 decibels. The 11th of November, 1 o'clock in the morning. So that would have been the night of the 10th, going into the 11th of November, rather than trading on the night of the 11th.
Thank you. And the other question was, there was also an alleged conversation with the DJ Jake Jones, and it's alleged that this conversation took place, and if it did, he didn't accept that he was asked to turn the music down. So obviously, we only know that. So if you could, if you're able to give any details about when that was, who it was, any details at all?
So the only time I've met Jake Jones was on the 25th of August, when myself and 2 colleagues were working late in the evening doing licensing visits. We went towards the last place standing issue because of the volume of noise coming from that direction. When we stood outside, it was not extremely loud. The 3 of us gone into the premises to find the DPS or manager on at the time. Jake's come out and spoke to us outside. When we asked him to turn the noise down, if we explained it was set by the DJ, he can't do anything about it. That's it. It was quite abrupt. It's kind of the end of the conversation.
Thanks.
Would you like to respond to either of those points?
Yes, in terms of the day we were not open, regardless even if it was the day before or after, we were closed by midnight, we're actually shut. So this was at 00:55. So again we say, even if it was the day before or after, it still wasn't us trading at the time. Certainly, when we saw this allegation yesterday afternoon, I was in the pub. We asked the manager, did he say those words? He said he didn't. There's not really much more I can say because it's not in writing. We just had his word for it and we have a differing account. So I couldn't really proffer anything more in respect of that. But certainly you've got the DPS here And so I don't think there's been any allegation over the years that Simon's been obstructive or not engaged. I think it's quite the opposite.
Okay, thank you for that. Carol?
A small question really, following from that. The DJ, is that a DJ who often operates in your premises? And in which case, would that be something, well, I know the noise limiter is going to be there, but is that something that, you know, would be followed up with that DJ?
I think there may be a bit of misunderstanding, miscommunication on those lines. Jake is a premises manager and is undergoing my tuition and apprenticeship. Recently passed his apprenticeship at City College. I'm trying to get to the point where he's confident enough and capable to deal with the responsibility of dealing with the authorities. With regards to the equipment that historically has been in place, I have sound engineers on payroll, so they do a fair amount of work with like setting up the speakers, particularly if we have a band, etc. So the equipment tends to get set by the sound engineers, go, right, this is the noise that we're expecting, this is the noise they're trying to write, this is what the limit gets set to. Sorry. This is what the noise is then sort of set to within the parameters of what we're expecting to be able to do on that night. So for instance, there's certain genres of music that we don't allow there, which every time that's slipped through the net, somebody's come in and played a genre of music that's otherwise banned, that DJ is removed from the roster and they don't come back. And artists that don't respect the equipment, that interfere with the equipment, interfere with the speakers, again, are dropped and do not come back. So I'm very strict on with that regard.
I think that the short answer is that if a DJ performer doesn't uphold our values, then I would invite it back. And certainly this only be heightened after the application has been granted, because we know how precious such a licence is. So I think today's really brought it to the fore. But as you mentioned, with the limiter, it's not a DJ can want to do something he can't do. So.
But basically it's a variety of guest DJs who come in depending on what the theme of the night is.
As a grassroots venue, we cater to a broader spectrum, so we, from ethnic minorities all the way through to platform for LGBTQA+, and along with other genres and niches within Norwich that satisfy various sort of communities, that wouldn't ordinarily get acknowledgement or recognition or the ability to play in another larger, more established venue. So we are that kind of niche markets that trying to put something in place responsibly to allow different communities to have their sort of platform, their ability to sort of entertain and be entertained.
What genres do you bar then?
I find that we've worked in the nightclub scene, or the sort of Norwich nightclub scene since 1997, so I've got a reasonable amount of experience of what genres of music tend to cause headaches and what tend to be sort of acceptable. So there's certain genres like, for instance, jungle and drum and bass that I steer away from, because those genres only have a sort of certain stigma towards a drug culture, but also that genre of music tends to get people a bit excited, and I find that in order to manage an event where there is that genre of music being played, I need extra layers of protection, such as increased door presence and security presence, random search policy in place for alcohol, knives, weapons, drugs, etc. So I've got extra layers in place for stuff that is then restricted to trusted promotion groups. So it's not something that you couldn't just approach them and go, oh, I play drum and bass, and the drum and bass DJ can come play your pub. The answer is no. The privilege of those genres is restricted, and there's some genres like the harder genres of house music or trance music, stuff like that. I don't know how to answer.
I think this is somewhat an aside, but I think to Simon's credit, we haven't got outstanding record from the police. There's no evidence of any incidents, no evidence of drug taking, drug dealing, etc. So yeah, I think it's just credit that we've got this far. We're not even mentioning a crime as sort of license objective. It's not mentioned anywhere in any of the papers.
Thank you. On the point of other licensing objectives, how did you want to answer this question?
Yes, it was just on page 27 where you mentioned the protection of children from harm, children who are discouraged from the bar area and then permitted in the garden area, and whether that needs maybe slightly changed wording or a bit of clarification in terms of if they are only, discouraged, only in the garden area, and, how do they access toilets?
I'll respond to this one. When we're looking to reinstate an lapsed licence, it's good practice to apply exactly the same terms as previously applied for. So there's no criticism from residents who don't understand the process that we're trying to pull a fast or be sharp. What I would say is that with this 64 Act, obviously this was licensed for hundreds of years, children were discouraged from pubs. If you were under the age of 14, you couldn't be inside the bar. It was very archaic, and so with Licensing Act 2003, unless there's an issue with underage sales, there's not here. It tends to be far more children friendly. So what we would say, Chair, it's up to you if you want to grant a licence on what grounds. Perhaps that's a condition that can be removed altogether, so I don't think it's particularly relevant to what we're talking about today. I think that's what someone would think.
Yeah, I do have my own policy with regards to children, which makes things easier for us at an operational level to deal with, and that's because we lead in towards like the music. Because we lead more into sort of the music and more adult styles of entertainment, I tend to say no children past 7:30 because I don't feel it's going to be responsible to expose children at a young age to that style of environment. The minor exceptions to that would be like an 8 o'clock instead of 7:30 if Norwich City are playing at home and a parent has brought their child out to the football game and they wish to come in and have a quick drink, a refreshment, might feel right. And if there's a late kick-off, then obviously I'm not going to be sort of telling a parent that they have to remove the child.
I think just to answer it again so very quickly, it's something that I would suggest is sensible to be up for manager and good practice rather than something actually that's prescribed a condition. But that's just a minor point suggestion. Thank you.
Okay, thank you. Are there any further questions?
Probably a technical one. The limiter, is that for, does that work indoors and outdoors?
Correct. Both indoors and outdoors.
Okay, there are no further questions. I'll invite you to make any closing remarks.
Chair, I've got a few myself. Do you really wish to cover some of the matters on the brain this evening? Okay, before it was closed.
Okay, we'll hit from David first, and then if you respond to that with any closing remarks.
Great, thank you. Nice and straightforward. Page 27 says libraries against over 30. The application is for over 100 close, so if that inconsistency could be remedied, please.
Yes, I mean, it's, we replicated the existing conditions. Normally you'd expect the town loud for radio entertainment to mirror that of the opening hours. If you wanted to extend that, we'd be very grateful.
It's just you're applying for what they are, I think.
Correct.
But you're also saying the libraries ends at over 30.
Correct.
Which makes a bit of nonsense of applying to one.
I don't necessarily think it does, because you have a wind down period. The music ends when you have a wind down period and you close.
Yeah. Sorry, unless I've misunderstood, your application is for live music until 1 a.m.
Oh, so you mean the consistency?
Yes,
So-
indeed. So page 15 of the agenda.
Sorry, I completely understand. So that was a follow-over from the previous licence. So the conditions should override the hours applied for. So yeah, did use that as a series of 30. Sorry, I misunderstood the first one.
So page 15, all days, closing hour, reduced to over 30.
Yeah, the closing out of live music, not the closing out.
Yes, yes, yeah.
And presumably page 16 and 17 as well.
Yeah, that's correct, yes.
The condition only says live music on page 27, and recorded music the line below will only take 100 hours. So I think you'd be keeping to the 100 hours. Unless there's a change there. So regarding page 27, again, speaking of the children will be discouraged from the bar area, only permitted in the garden area. I mean, the obvious point is toilets. From the point of view of the appropriateness of rewriting the condition, it's not clear that the council would wish to do so if the licence is granted. Would you have any suggestion as to amending your own condition? Make things a bit easier.
If I was applying afresh, I wouldn't have proffered these conditions. They're out of date, archaic, and don't follow your model conditions. I would actually say, in respect to children, as I said previously, if you're happy to remove them, I would suggest just to remove them. I don't think it's actually necessary.
The plan on page, third line down here, ground floor, seems to cover a bit of the public highway. That's page 35, is that it?
So,
The licence boundary.
shall I explain from a technical point of view? So, there has previously been a tables and chairs licence, or a payment licence in place. Therefore, we would suggest to actually keep the red line as is. It's not currently being used.
The advice committee have to keep it in, as it were, open committee, is that I'd be concerned with the clash between highway rights of persons and your ability to control any area that is highway, from the point of view of prohibiting children, classes as per the police suggestion, and so on. Frankly, you simply can't do it, they can't match. You can't prohibit persons from the public highway, and therefore last entry, for example, simply wouldn't work.
We do have tables at front removed at 9 o'clock.
Via a pavement licence.
This was granted historically in sympathy by councillors following the continuing closures and of the renovation and pedestrianisation of that area of the street adjoining the front of my shops and up to including builders fencing off the building previously to actually access the building. This was done in absence of any notice consultation with the previous owners. So, when the licence was transferred, it was transferred as was. So, licence was granted for a small area, or permission was granted for a small area out of which said that if you cordon that off with capital batteries and use that sort of you are then essentially should anyone cause nuisance, it's just within the responsibility then. So this is, I'm going by a conversation had 4 years ago.
So can I just check the current policy, where you have a paid licence in place, do you expect it to be serviced by way of off sales and not actually within the red line area of the licence?
That would be my expectation. I don't know. I don't know if the licensing team can assist.
I don't do pavement licences. I don't know what the policy is for pavement licences. I do tables and chairs.
Consumption of alcohol not being a licensable activity, so tables and chairs on the highway would be authorised under the Highways Act.
Yeah, we usually have off sales to allow for tables and chairs. I should imagine it'd be the same for the pavement licence.
I believe we've got unrestricted off sales as applied for. Obviously, we're a new licence, so we can't take advantage of the new regulation. But from what I can see, I don't think it impacts if we actually remove that front area from the red line area. But obviously, we would have to then launch a new route plan. But certainly, we can say we do that.
That's my concern. I think that would be a sensible way forward to struggle with conflict with highway riders.
As far as I can see, there's no restriction on sales, so it won't actually impact upon.
The current application, as you say, is for sales as well.
Yeah. And there's no seal contained condition.
There's a discouragement from taking over.
That's what presentation is also.
Which again is well on the way to unenforceable. The discouragement is whatever.
I think it's taken away from the premises, isn't it, as opposed to.
Yes.
I'd be happy enough to say that if there's people drinking in a pavement area, that's not actually breached that condition.
The pavement licence should give you authority to at least object if the licensing premises licence shouldn't be granted was enforced in that area.
Sorry, say that one more time, sorry?
If the red line is moved to the physical boundary of the building,
yes,
at the front, then the police persons discouraged from taking open containers off the site would affect the persons at the door. But it would be hardly in the public interest for the payment licence existing to wish to enforce it.
Yeah, so it says off the premises, it doesn't strictly relate to off sales.
The premises, if that red line goes back to the building, which as you'll guess from my comments, I think it should, would mean drinking on this street would be via a pavement licence on the presence. Sorry, drinking on the street would be via the off-licence sales, consumption not being licensable, and any table and chairs on the highway would be authorised under the pavement licence, not the premise licence.
Yeah, so I think if you're wanting to grant, it's limited, that patrons will be discouraged from taking open vessels of alcohol off the premises, perhaps at commerce, say for immediately outside the pub. I think the police's intention is they don't want people taking their pints and wandering through town with it, which is perfectly understandable. But I've had the same issue a few times where it gets, you're very pedantic about the wording, it can become troublesome.
Off the premises brackets, save for consumption at authorised tables and chairs at the front of the premises and
Or in an area authorised by tables and chairs or appropriate pavement licence. So no doubt change the legislation in 2 years' time.
David, are there any further points you want to raise?
Thank you, Chair. No. Late night refreshment is indoors only, I noted. I didn't know if there was a reason for that.
I don't think you're having any teas or coffees or hot dogs or anything else around the garden, are you, for 11 o'clock?
Not wanted. No, thank you, Chair.
Okay, thank you very much. So if I hand over Mr. McCann, ready for final closing remarks for the next determination.
Chair, do you want me to close first, or is it normal for statutory authority to close first?
I'd be guessing better for the appellant to go last, sorry, the applicant to go last, so
Okay, yes, my apologies. That's not my hand to you.
Talk on the further nice way, because all the comments we've made definitely raised our written submissions, and we have no further comments to make.
Okay, thank you very much. Mr. McCann.
Yeah, thank you, Chair. I'll just speak 2 minutes. Just to leave you with this, that if a £23 fee had been paid, a transfer application lodged, which would have been granted, it's only not granted exceptional circumstances, we wouldn't be here today at all. There'd be nothing to consider. The complaints made thus far fall well short of what would be deemed suitable for the review application at this stage. We have tried to work with the authorities. The complaints made, they are still very scant in terms of what the allegations are. I know you were concerned about the recent complaint made at the end of December. What I would say is that was using the old equipment without a noise limiter, rather than what we're proposing now. And certainly the monitoring equipment in this person's flat or apartment or house, I'm not sure which, is switched on by them, and we still don't know whether the noise is coming from us. It could be, it sounds frivolous, a house party next door could be causing for nuisance. Regardless, we are determined to work with the statutory authority, particularly environmental protection. You've seen the conditions we've proffered. We say they're absolutely foolproof. And certainly, you've heard from Simon, he's on the premises 5 days out of the 6 days it's open, on sickness or occasional holiday. And hopefully we can put this behind us and operate in such a way that no residents are disturbed. We still have a business that can encourage the grassroots, has the revenue, continue trading, doesn't have to shut its doors for good after literally hundreds of years of continuous trade. Is there anything else you want? I think I've spoken far too much, so I'll leave it there.
No, not sure. Thank you for your clarity in all of that. Okay, then on to the points here. So, are you happy for us to organise an advice determination?
kind of you to ask, Chair, it's your committee.
Well, there's nothing further you want to raise.
No, there isn't, no, thank you.
Great. Okay, thank you very much.
To assist the parties, it might be helpful to give an idea of how roughly long it takes the opportunity to go away and have a coffee or something.
Yeah. We'll aim to be back in half an hour. In that case.
Can you say no decision before 1:10 past 1, Chair?
Yes.
We won't go far, don't worry. Thank you, Chair.
Okay, thank you. Okay, thank you everybody for waiting for us to make our determination. So, in considering the application to grant of the premises licence in respect to last outstanding, we decided to grant the licence. We have some amended conditions which I'll hand over to David to run through now.
Thank you, Chair. With apologies, as this is really rough and ready, and in summary only. The police conditions are noted as agreed by the applicant on page 36. Committee amends to try and take account of the outside area at the front of the highway. So bullet point 3, patrons will be discouraged from taking open vessels of alcohol off the premises, save for consumption at an area authorised by tables and chairs or pavement licence. The second matter is there's no licensing of the public highway, so the bit in front is not licensed. So effectively that's a refusal of application in that respect. The next point is the conditions put forward by the applicant, which are appreciated as per the email of 4th January with some changes. So no change to bullet point 1, no change to bullet point 2. Bullet point 3, noise generated by amplified music must be controlled by a noise limiting device which is tamper-proof by authorised persons and which is set at a level determined by the local authority environmental health officer, such level being confirmed in writing with the licensee. Bullet point 4, except in instances of technical failure, which will be reported, etc., no change to the words in brackets. Noise limiting devices, once set, cannot be reset or adjusted without the approval of the local authority environmental health officer and to a level determined by the local authority environmental health officer. Bullet point 5, additional words at the front. The premises licence holder shall ensure that no noise generated on the premises, etc. Ending gives rise to a nuisance. Bullet point 6, small typo amended, which is the elderly clause, that comes out. Otherwise, no change. Condition number 11 on the old licence, I think with the consent of the premises licence holder is removed as out of date and fairly unenforceable anyway. Then condition 5, I think it is agreed that you'll be able to confirm this is dealing with Norwich, which I think are similar. If that still exists, then that condition is fine and can be continued with. So that's still good, thanks. Those conditions, as per the 4th January email as amended, are understood to come into effect, and this is effective in proposal. Once the equipment is installed and the level set. But until then, no regulated entertainment may take place outside. Reasons very much in summary. There have been noise concerns, and these are felt to have been justified. The EPA 1990 notices have been served after investigation. We have written representations of local residents. However, committee after hearing from management today feels management is acceptable, and the conditions as amended should prevent noise nuisance arising both inside and outside from regulated entertainment. There are no concerns regarding crowd disorder. There are no outstanding objections from the police, and the committee notes environmental health concerns regarding management, but on balance, as mentioned, the committee feels management is acceptable, and therefore it's appropriate to continue to give management a chance. Chair, was there anything I've read that was wrong or you need to add?
No, thank you very much, David. That's a full summary of what we're going to do.
The following writing, as there have been changes, obviously 21 days right to appeal, which your legal representative will be able to clarify.
We won't be appealing. I very much understand. Thank you, Chair. Thank you to everyone here for your time and for a very well run hearing. Really appreciate it. And of course, we'll continue to work with environmental health.
Great. Thank you. That's
Good afternoon. Thank you very much.
Thank you very much. That's this regulatory subcommittee finished now then. Concludes our business.